Namaskara and welcome to BIC Talks, a podcast brought to you by Bangalore International Centre, where we present conversations that move, inform, and encourage discourse.
In the early days, even in 2003, the conception of our work was how to adapt mediation to the Indian legal system. It was postured with the goal of acceptance. With the moves I described and with the leadership of Sriram and Niranjan and many others, and the invaluable contributions of you here today, the foundations and processes and centers and practices are more than established. This does not mean that all of the current structures and policies of the court system are conducive to the growth of mediation. They are not. As I've noted earlier, one of the reasons that mediation and other settlement processes work in the US and other places is because the parties feel the sweat on their palms of imminent jeopardy. Take that incentive structure away and mediation efforts are much less likely to succeed. And that work, the ways in which courts and cases are managed, must be a continual priority for anyone committed to the growth of mediation in the formal system. Without this support, however, this imposes an even greater burden on mediation. It has to be that much more powerful, so good, so strong that it overpowers the perverse incentive structure that keeps it from succeeding.
In this episode, renowned scholar and innovator in higher education and global justice reform, Hiram Chodosh presents both a political and a local perspective to mediation in India. Together with internationally recognized Indian mediator Sriram Panchu, he discusses the virtues, capabilities, and skills that makes mediation a powerful response to conflict. They evaluate mediation in practice, including in the USA, within courts, communities, legislative bodies, international relations, and the role of professional mediators and lawyers in this practice. This episode was adapted from an event that took place at the Bangalore International Centre in January of 2025.
First, what is the nature of the challenge that mediation is intended to surmount? Here I want to step back and talk about conflict. With due attention to the impediments and limitations of mediation, why is it successful globally and here in India? And here I want to talk about the power of mediation and three big lessons that I've learned from all of you going back now 30 years from the first moment I was here in India. Third, what is the future path we wish to deepen, broaden, and expand for India mediating? Here I want to talk about our shared commitments and how to actualize them this morning, this afternoon, on Monday, and beyond. So first, the challenge. Conflict is endemic to the human condition. Our species survived and prospered not because we were taller or had bigger brains, but mainly because we were profoundly social and developed ways to coordinate across our differences. Harari teaches us that gossip and fiction were the two keys to the thriving of our species. Gossip reflects a social focus, at times excessive, we all know, with what others are doing. And fictions help us overcome our differences, not just the stories that move us, but notions of truth, nation, religion, justice, peace, property, family. These are concepts that we have created and draw on to form one society out of many different people, one civilization out of many societies, one global community out of many civilizations. Because these constructively ambiguous notions are so profoundly binding for us, we fight about them too. What is constructively ambiguous can be destructively ambiguous too. What is true? What should a nation stand for, and what should its law and policy be? Which religious or non-religious practices should prevail? Which notion of justice should we apply? Can global peace ever be just if there are winners and losers? Who owns what? What is the proper regulation, if any, of our most intimate social relationships, our families, the proper distribution of intergenerational property? These are vital questions for each of us, for all of us, and we cannot answer them without conflict. Here, everywhere, we must see conflict as good and bad. Conflict is a creative social process. It sparks change. Adorno saw success in art as a negative harmony with inner structures of pure and uncompromised contradictions. Hume taught us that truth emerges from arguments between friends. Dewey urged that conflict instigates invention. In these aspects, conflict is good. Conflict, we all know, is also destructive, costly, emotionally draining, economically, socially, and politically frustrating, impeding, devastating when it turns to violence and spirals into irreversible, vicious cycles of endless retaliation. In these respects, conflict is bad. So if conflict is good and bad, we must frame a question with twin goals. In our lives, our families and communities, our work and professional responsibilities, our business and our politics, our international relations, how do we get the best of conflict and reduce the worst of it? Second, the success. Today, we explore one powerful answer to this grand challenge: mediation. Mediation is a method for resolving conflict in ways that maximize the good and minimize the bad. Like all other human endeavors, mediation is imperfect. We cannot completely preserve the good and totally eliminate the bad. However, we can strive to these ends through both critical reflection and creative response. Like justice and due process and peace, mediation is a human construct. We may disagree about it, what it is in its essence, how it should be practiced and regulated, but in its essence, mediation is a cluster of communicative social processes that work to prevent, neutralize, mitigate, and resolve conflict. There are two primary interrelated toolboxes of social exchange and mediation. The first is a series of facilitative communication strategies and techniques that are designed to neutralize negative aspects of conflict. These are responsive to a wide array of conflictual expressions. Disdainful refusal to communicate. I will never speak to him again. Excessive anger. I hate her. Unshakable disrespect. He's a monster. Surmounting emotional pain. I will never get over this. Such processes in response to those expressions include, in mediation, joint communication to reestablish respect, acknowledgement to ensure people feel heard and seen, neutral questions and reframing to get to the factual or emotional bottom of the matter. The second toolbox contains a series of negotiation strategies and techniques that offer thoughtful, wise perspectives and practical, effective steps forward. These attempt to get beneath the surface of how the conflict is conceptualized or expressed, to find a deeper value or perspective shared by those in conflict, to identify an underlying interest they have, to take a future-looking perspective, even to find at some points a third party, not directly involved in the dispute, who can help invest in the conflict with an integrated bargain. These strategies range from positional bargaining based on comparative merits and probabilities, including practical considerations like the time value of money or the cost of agitation and litigation, interest-based bargaining that takes stock of what matters most to each party and looks forward, not only back, and integrated bargaining, that offers the opportunity to attract other party investments in resolving the conflict in exchange for some return on that investment. Now, over the past half century, commitments to explore, develop, and apply these processes, both within and outside the formal legal system, have grown. This is in large part driven by favorable contrasts between mediation and European-centric forms of adjudication. Mediation is consensual, not obligatory. It's interest-based, not purely positional. It's party-driven, not dictated by authority. Participatory, not confined to a more passive role for litigants in a play performed almost completely by lawyers and judges with their own language and formal ways of talking and deciding. For these reasons, throughout North America, Northern Europe, Australia, many other places in the world, mediation became more attractive, especially during the 1980s and 1990s, and remains a major feature of the way people resolve disputes and a wider diversity and also in a wider diversity of conflicts outside the legal system. Proponents of mediation today, for example, will boast a success rate of 75% of success in resolving cases through mediation. Now, this statistic may be misleading in its application to systems that cannot ensure fast and continuous trials with a strong measure of temporal certainty, in other words, sweaty palms on the eve of imminent jeopardy. But it's an impressive data point nonetheless. In this global context, the very first exploration of mediation here in India emerged in 1995. And I want to tell you a little bit of this story because I think it's very important. And I know Sriram has many stories to tell, and I can only get at some of the highlights from my point of view here. But really, we should ask ourselves always when we're trying to move forward, what brings us to this point? What brings us to this point 30 years later? Why should we celebrate how far Indian mediation has come? Why Sriram and I both intend to start a fresh conversation and a new series of commitments to advance its cause. How can we support, in particular, a new, young, brilliant, ambitious generation of mediation experts in India, many of whom are here with us in the audience today? Well, how did I get here, and what have I learned from all of you along the way? Well, here are the broad strokes. The late Chief Justice Amity commissioned the study of delay in the civil justice system in late 1995. I served as the young academic reporter on that 5-city study. The report was later published. Abhishek Singhvi, whom you know, was a co-author of the study. And when Chief Justice Amity, or right before he stepped down, he took the final report to the Law Commission. The Law Commission studied the report, did its own research as a basis for drafting procedural reforms in the form of Section 89 and Order 10. Some of those provisions matched the recommendations in the report. Others did not and were oddly drawn from European practice or models. Parliament passed the legislation in 1999. The bar did not receive these changes well, I think largely because of the European models that were incorporated in the law. And the implementation was suspended until 2002. In the meantime, working in parallel, and before he joined forces with Sriram as a co-lead on so many important mediation projects in India, my dear friend Niranjan Bhatt from Ahmedabad, who passed away about 18 months ago, and I worked on the introduction of mediation processes to the Indian legal professionals and judges. And Sriram simultaneously was doing his own work at NYU and then back in Chennai. Niranjan held the first national conference on mediation in India in 1998. Over 500 people attended. Just as the legislation was going into effect in 2002, I received a Senior Fulbright Award and dedicated my time here in the spring of 2003 exclusively to the growth and adaptation of mediation in India. In that spring, Niranjan, Firdosh, Karachivala, and I developed regional workshops and materials that we published into a book entitled Mediation in India. Again, Sriram was doing very sophisticated work on mediation in parallel, and around that time or shortly thereafter founded the first really robust mediation center in Chennai. And many centers and practices have developed since that time. And of course, as you all know, with Sriram's leadership, the Indian Mediation Act is now firmly in place. Modules and law courses, focused professional trainings are more pervasive today. Private mediation practices or centers are beginning to emerge in the wake of a major push on court-annexed mediation. So much has developed in the last 20 years that Sriram can speak to with much greater authority than I. But I want to talk about that spring of 2003, because it was during that spring and for the next few years that I learned some very important lessons about mediation in India. And there are three that I want to highlight here today to form the foundation for what I think is a big pivot for mediation in India. 1, curing indigestion. 2, a non-Euclidean qualification of self-determination. And 3, mediation without mediators. 1, curing indigestion. In the early years, from 1995 through implementation of Section 89, in convening after convening, especially those in which experts outside of India would present to judges and lawyers within India, I observed a major difficulty. Mediation was presented as a system, interwoven into the court-wide menu, judicial settlement, early neutral evaluation, annexed mediation, all kinds of other practices. And further, each of the many processes took on litigation-like formality in the way that they were presented to audiences. This is how you greet the parties, introduce your role, hear from each side, pose questions, conduct private sessions, seek compromise, formalize agreements, record with the court. This to me sounded like a bunch of procedures. And rigid axioms and preconditions were set, including one at the core of my next lesson. But mediation as a system, designed and practiced in California or Germany or Australia, was, in a word, for Indian audiences at the time, indigestible. It's as if we all had a certain definition of a pizza, how it should be made, the ingredients it must have, and presented it as an entirety. An entirety in which any missing part would make something less than pizza. Wheat flour, not chickpea. Cheese, never paneer. Tomato sauce, not curry. Pepperoni, not vegetarian. Oregano, never cumin. My Indian friends and colleagues would listen, at times in awe of these systems, but there was no path forward, no way to figure out what to do on Monday. How can I make pizza when it violates my dietary restrictions, when I may not have these ingredients, when it doesn't fit my taste, or I don't have the right sized oven? Even if these questions had been posed, there was no place to turn for an answer. So when Niranjan and I thought this through, along with Chodosh, in the first regional workshops, we took a different approach. Instead of presenting a system that was already well developed in a certain systemic context, we presented mediation as a cluster of these independently important communication strategies and techniques, some purely communicative, some others focused on negotiation. And the social examples we used to teach them, the pedagogy we used, was essentially Indian. The examples we used were Indian. The strategies we drew on from Indian contexts, both formal and informal. And this created space for very creative Indian strategies to emerge later. So, for example, in teaching about the necessity of joint communication, we all know that you cannot have mediation without some form of joint communication. One of my senior colleagues in Hyderabad said he knew exactly what I was talking about. And he explained that he had a case in which a couple he knew were not talking to one another, and he wanted to resolve it. Why weren't they talking to one another? Well, the wife would not talk to the husband because the husband had donated a kidney. Well, that seems like a wonderful thing to have done. Why wouldn't she talk to him? Because he had not conferred with her prior to the donation. So I asked him, what did you do? He said, well, I invited them for tea and put them in my parlor, closed the door, locked it. I was like, wow, that is a very crude way to create joint communication. Then what happened? He said, first hour, silence. Second hour, yelling, screaming. Third hour, talking, listening. Now, that sounds like a very crude insight, but when you teach that, then all of a sudden you see the direct line to years later in Delhi, a young mediator who had two brothers in his chamber who weren't talking to one another, who wouldn't even look at one another, who put their seats back to back. What he did was he recognized that the older of the two brothers was his elder. So as a show of respect, he went and touched his feet. Then at that point, the younger brother had no choice but to go touch his elder brother's feet. Otherwise, he would have been disrespectful not only to the elder brother, but to the mediator. As he touched the older brother's foot, he rose and the older brother hugged him and was crying. And he said, all I ever wanted was your respect. And that's the kind of process and story that there are so many of here right now in the country that need to be told, surfaced, and perfected and disseminated. Or, to take another example, from a social context of integrated bargaining. Our cousins in Mumbai had done an early day redevelopment of their property. A bank had come in, financed the family and their tenant on the first floor to go off and live somewhere else for a year or two, build up a couple more stories, sell the top stories, and then everyone had a new apartment and they had settled their landlord-tenant dispute with their tenant. It's an integrated bargain. The third-party investor receives a value on their return, a return on their value. So years later, again, a mediator looking at a couple who was really struggling with conflict. Why? Because the husband had a devastating blood disease, came up with an idea. Is there anyone outside this party structure who can help with the underlying medical condition? And he convinced a friend of theirs to donate the resources they need to pay for the medication to not cure but manage his disease. That alleviated the conflict between the couple and they resolved their difficulties. Integrated bargaining. Now, in each of these examples and many others, there was no translation of social process. There was no indigestible system to have to swallow. This was India mediating outside the scope of common practice abroad. This was India mediating in its own way to achieve its own objectives. Second lesson, the non-Euclidean qualification of self-determination. Why do I say non-Euclidean? Well, one of the most powerful experiences I had as an undergrad was I took a course called The Nature of Mathematical Thought. And it was a course in which we had to develop mathematical theorems from scratch. So we were given Euclid's postulates, his axioms, his 5 elements of geometry, and we had to create our own theorems from those 5 postulates. But then something very profound happened. Our professor took away the 5th axiom, and we had to create new theorems with only 4, completely different worldview. Then he took away the 4th, and we had to create a whole new non-Euclidean geometry from just the 3. And that really stuck with me. And so, flash forward, one of the central axioms to mediation, you can read this in the ABA standards, is self-determination. That the parties shall be self-determining in their agreement to a settlement. That is just paramount. But there was a problem with this in the Indian context. And during the early days of mediation here, when my friends would tell me about their exploits and the tremendous family conflicts that they'd resolved, they'd say, "Oh, Hiram, I am settling in only 8 sittings, or 8 sittings only." I was like, 8? Oh yes, we had to go see the in-laws and we had to go over here and meet these people. I was like, wow. And at first I was very critical. I was like, no, you can't do it that way. You have to have everyone around the table. And we know from the axiom of self-determination that the person at the party that's mediating has to have authority to be able to sign the agreement at the end of the continuous process. Well, I quickly understood that's ridiculous. And it's not because people in India aren't self-determining. It's because that there's such a tightly knit social structure that if I'm a young person or even an older person and if I have to resolve or settle a dispute, I can't do that completely on my own without consulting at the very least. I have to talk to my dada, I have to talk to my papa, I have to talk to my mentor, I have to talk to my friend. And some of those people have actual interests in the dispute itself. And so this rigid notion of self-determination in that sense, in that context, does not make sense and really needs to be softened to a more flexible notion of recognizing the conditions in which people live and the intertwining interests that people have. Now, you can view that as a constraint, but again, flashing forward to mediation in practice in India, I know of many cases in which that has become a strength in the mediator's approach to resolving a dispute. Why? Because sometimes those parties who are just on the outer orbit of that immediate conflict, who have an interest in it, can actually help resolve the dispute. One case, 2 elderly brothers were not talking to one another, obviously a family business. The mediator reaches out to their sons. This would never happen in the United States, I can tell you. Reaches out to their sons, has the sons come in, explains the situation. Who really resolved the dispute? The sons resolved it. Why? Because the sons said to their parents, "Please do not bequeath us your silly conflict. We want to be brothers. We do not want to be like you. So when you're considering our inheritance, don't give us that." Last of 3 lessons, mediation without mediators. Now, both the first 2 lessons provide a foundation for this one. My point is that mediation can occur without a mediator or a formal mediation process. In the early days, many of my colleagues training in mediation would report back, "Hiram, I'm a better lawyer now. Hiram, I'm a better father. I'm a better spouse. I'm a better wife." They were better at what they did at home. How could this be possible? When we think about, by analogy, sports or formal athletics, like cricket or football or basketball, can we play these games outside the formal setup of a match? Of course we can. When my 7-year-old came to India with us in 2003, he played cricket in the park every day with a little boy next door. Was he not playing cricket because they played cricket without an umpire, without a marked pitch or a complete set of wickets? Further, let's say that he wanted to become a great bowler, and if he were practicing against a wall or a garage, as I used to teach myself how to play soccer against a wall or a garage, would he not be playing cricket? Of course he is. Now, applying this to mediation, when we engage in direct negotiation, there's no mediator there. We can internalize the facilitative communication skills of mediators by acknowledging the force of opposing claims, by asking neutral questions of one another, by delving deeper into understanding our shared interests or aims. I don't have to have a third-party mediator to do this when I'm engaged in conflict. And that might be called bilateral mediation. Now, that's more than just pure negotiation, folks. Also, in our individual anticipation of a conflict, We may draw on mediation capabilities. Why is that person acting so rudely? What is going on in their lives that I maybe don't understand? Instead of having a hard opinion, might I convert my conclusions into questions and then look into the matter more deeply before having or continuing to have such a hardened view? What am I doing to feel such anger? Can I look at my own views and attitudes to find out what's really going on? What's going on inside of me? Why I care so much? What would make me feel better? This is what might be called unilateral mediation, where I'm not even engaged with another party and I'm still practicing mediation on my own. Now, that's more than just a strategy for settlement or peace. And finally, there is one more that I want to mention. Don't we all experience internal conflicts? Dilemmas of choosing choosing unsatisfactory options? Ethical quandaries that make us question each side of our internal debates? Is mediation any less useful there? No. Actually, I think it's even more helpful. Because when we're clear in our own thoughts and actions, we help prevent the bad and make the best of our own internal conflicts too. And this is what might be called intrapersonal mediation. And that may be the most important mediation of all. Now, all this leads me to the path forward and the big pivot from mediation in India to India mediating. And it's informed by these three lessons and many others each of you have learned and taught me, from adaptive acceptance of mediation to creative leadership for it, in it, of it, through it, for ourselves and others. In the early days, even in 2003, the conception of our work was how to adapt mediation to the Indian legal system. It was postured with the goal of acceptance. With the moves I described and with the leadership of Sriram and Niranjan and many others, and the invaluable contributions of you here today, the foundations and processes and centers and practices are more than established. This does not mean that all of the current structures and policies of the court system are conducive to the growth of mediation. They are not. As I've noted earlier, one of the reasons that mediation and other settlement processes work in the US and other places is because the parties feel the sweat on their palms of imminent jeopardy. Take that incentive structure away and mediation efforts are much less likely to succeed. And that work, the ways in which courts and cases are managed, must be a continual priority for anyone committed to the growth of mediation in the formal system. Without this support, however, this imposes an even greater burden on mediation. It has to be that much more powerful, so good, so strong that it overpowers the perverse incentive structure that keeps it from succeeding. And with this in mind, the maturity of mediation in India leads us to a new and exciting phase, one in which India is not merely accepting, but contributing, not following, but leading, where this movement is not conceived as mediation in India. Instead, it is to celebrate, surface, cross-leverage all that has been learned and will be learned in the future here and abroad from India mediating. India mediating leads to three concrete opportunities. First, a uniquely Indian pedagogy of Indian mediation, the opportunity to work together to surface the stories, to qualify, disaggregate, disseminate the virtues, values, capabilities, skills, and processes of mediation that have been developed uniquely here in India over the last 20 years. Second, a popularization of mediation outside the legal system that I know many of you are doing tremendous work on. The opportunity to relax the assumptions and systemic dogmas of mediation so that people can see its value and use in each and every disaggregated practice in their own lives, at home, with neighbors, at work, in local, national, and even global matters of policy. Mediation as a response to problems in the legal system carry two propensities that we should try to avoid in this. One is to avoid mediation looking like and acting like the process it's supposed to replace. A second is to instrumentalize it for the system and become blind to its greater social value. By thinking about mediation broken down into social processes that are available for universal, prosaic, even non-legal forms of conflict, we can avoid both limitations. And finally, third, the dissemination of that popular pedagogy within and outside the country. India has the opportunity to drive mediation deeper into the country with tools that are available to everyone, yes, but then to disseminate this externally in the South Asian region and beyond. One great way to grow a national movement is to lead a regional or global one. In sum, mediation is a powerful way to make the best and avoid the worst of conflict in our societies. India has something special to demonstrate here and teach us all, as it has taught me. Sriram, I know, joins in this covenant with our future. That is our promise. That is our commitment. That is our answer to conflict. That is our strategy to apply and learn from mediation as a powerful force. That is our charge to India mediating as a powerful force at home and beyond. Thank you all for your attention.
It's always such a pleasure to listen to a distinguished and incisive academic who's been on the field. Thank you, Hiram, for that, for those reflections, for widening the field, and for pointing concrete ways forward. Thank you very much. When we talk about mediation in India, people first start thinking of panchayats and Lord Krishna. And I have some difficulty in telling them that, look, panchayats were a little different from mediation. You couldn't refuse to go to a panchayat, and if you didn't agree to what they suggested, they pretty much told you what to do. And I wrote an article some time back on why I thought Lord Krishna was not a good mediator. And it drew a lot of spark, especially from the Vaishnavites. I reflected on the tools he could have used and didn't. But also the fact that that is how he wanted the result to be. Without that, the bookshops would not have the second epic. They would only have the Ramayana, they wouldn't have the Mahabharata. So with all this long history that India has of mediation and mediation-like activities, I think it's really the period late 90s, coinciding with the time of Hiram's study and work with Niranjan and Firdosh and the Supreme Court's initiative, that we got in these legislative changes, basically which enabled a court to refer a case to mediation. But the problem, with legislative changes is that they just stay on legislative paper unless something actually is done to concretize them. And they stayed on paper for a good 9 years. There was no mediation referred to by the court or anybody. And in Chennai, we realized this. So we were, for a long time we were working, trying to see how to bring mediation forward, and spoken to the bar, to associations, to business chambers. And then we realized two things. One, that for it to take root in India, you must move through the instrumentality of the courts. For it to take root, not always, but to take root. Because people will only feel comfortable with something in the dispute resolution field which is seen to come from court or have the blessing of the court. So with that very important realization, and our good fortune was we had Justice Kadru in 2005. Justice Kadru is a maverick in many ways, but one advantage of his being a maverick was that he caught mediation like that. And although all I asked him for was, please send a few cases to mediation, he called me and said, I'm decided to set up a center for mediation as a wing of the High Court. You will be an official body. I will give you space, I will give you staff, I will send you cases, most important. But I have no funds. Will you manage? I mean, who would not take up that challenge? So we kind of raised some money, brought over a trainer from the US. My dining table went to the High Court and became India's first court annex mediation table. So we had beginnings. But I will always remember the sixth case that we mediated. We had 5 that didn't work, and the sixth worked. The simple case of a contractor who had built a house, didn't get paid, and they came to mediation, and there was some agreement, and he got his dues. And the contractor's wife used to come with him for these sessions. The matter settled in 3 sessions. And after it was over, she touched my arm, and she took me aside, and she said, I have to tell you one thing. She said, my husband has cancer. We desperately need this money for his treatment. We couldn't afford to say it during the mediation because it gives the other side an advantage. But now that the check is handed over, I want to tell you this. And I said, I'm very happy to hear that, this is going to help you. Now, I had a lot of doubts about whether mediation will work or not, but those were all dispelled that evening. Because as she left that room, that lady turned back. She stopped at the threshold of that mediation center. And she said, I have to tell you something, sir. This is not just any ordinary room. It is a house of God. And Hiram, I knew. That time I knew this is going to click. There is no way it's not going to work. Some things give you that certitude. As an interesting sequel, 5 years later, I was driving down Nungambakkam High Road, and there was a knock on my car door, a couple on a scooter, and I stepped out, and they said, you don't recognize us, but we are that couple who came for mediation so many years back, and glad to tell you that the husband is treated, he's cured of his cancer, our children are doing well, and we're a happy family. And any mediator will tell you that he or she will hear stories like this by the dozen. That's the joy of mediating. So I think it's been a good strategy to work through the courts first, because we have made striking progress. Every high court has a mediation center. I think district courts are mediation centers. We've gone below district courts. We have a few thousand mediators. They mediate lakhs of cases. It's a wide range of cases. It's civil, commercial, property, family, matrimonial. And the success rates are fairly good. I don't think it's anywhere less than 50%. Some places more. So if you look at the picture, that on that side is very impressive. There are pluses in that. Because it means that the system has accepted you. You're not in conflict with the dominant system. The litigator system is the dominant, court system is the dominant. So you're not in conflict with it. We have integrated with it. We have a ready supply of cases. In fact, I like to tell judges that, you think backlog is a burden and a big headache for you. For me, it's a treasure trove. Just pick into your list of old cases and send my mediators cases. It's a treasure trove. So there's a ready supply of cases. So the court has infrastructure like nobody else does, brilliant infrastructure. They conduct training programs, they have all the infrastructure. So there is a spread and a density, and these are the pluses about the court annex system. What are the minuses? I think quality is the first. Because as the numbers grow, quality inevitably drops as you take in more and more. But the biggest problem is the low payment that inevitably is offered to mediators. It used to be pro bono, then it became an honorarium. Some places it's a little more, but it is still very, very low and not commensurate to the quality and the amount of time that people spend. And this is the biggest problem with the court sector. The third is the fact that it's sometimes a judicial bureaucracy which runs it. Now, these lead to an additional set of problems like lack of specialization. You can't really specialize if you're doing there. You have a lack of incentive to know more, to train yourself more, to equip yourself with better courses, to really follow the field. There is no incentive to do that. And there's no career path in court annexed mediation. So I think you look at both and you say, okay, we've done so far and so well with court annexed. Now let's shift the focus. Let's shift the focus to mediation as a profession, to institutionalize it and professionalize it as a standalone vocation. I think that is our challenge and mission. How do we professionalize the practice of mediation to make it a standalone career? Thereby we shift the focus from court annexed mediation. Not entirely, we don't depart from it. But while using court annexed mediation, we bring in these elements of professionalization. Because I think both parts are necessary. As mediators, we pursue a learned art. We pursue it in a common calling. We pursue it in the spirit of a public service. But it should also be a means of livelihood. And with these 4 sentences, I'm fitting in how Roscoe Pound defined a profession to be. So I think this is really the crux of what we must project for ourselves in the future. The Mediation Act 2023 is a beginning. And we have consciously framed that act to be in line with the demands of a professional activity. Some of us have been involved with that, deeply involved with that. So it has accreditation of mediators. It has provision for recognition of teaching institutes, training institutes, and mediation centers. There's a code of ethics. There are guidelines for practice. There's an institutional body called the Mediation Council. There's provision for online mediation, community mediation. There are some cases mentioned which shouldn't be mediated. I think it's too large a list. Hopefully that will come down. But importantly, it does something which I don't think is done anywhere else in the world. The Act says that if you have a mediation agreement, it has the status of a decree of a court. And I have not seen this in any other enactment, any other country. Some countries just leave it vague. Some say it has the status of an arbitral award. But the Indian Act gives us a status of a decree of court. So that come disobedience, you don't even have to go to a court to say, give me a decree. You have a decree. You just go to the executing court and say, execute it. But I'm going to tell you something about disobedience of mediation agreements. I've mediated since mid-90s, any number of cases. I've not had a single case, not one case, where a party who signed a mediation agreement went back to court or refused to comply with it. Not one case where a party refused to comply with it and the other party had to go to court to say, please enforce it. At the most, I've had, I think, 2 cases where a party said, I've agreed to these terms, but I'm in difficulty, I want a rescheduling. And they came back and we worked it out. I think very few people know this. One of the great bugbears of any form of conflict resolution through the normal process is enforcement. You come up a cropper when you come there. In mediation, the enforcement is really something you teach in the books. You never come across the need to enforce it. Why? Why would you enforce it? 2 people sign an agreement in their best interests. They sign the agreement, exchange the check, sign the document, and move on. As I said, we have the Mediation Act 2023. But once again, like as in 1996, legislation is not enough. And we need concerted action on multiple fronts. And I'll identify a few of these. I think we need to make business much more aware, business in the commercial world much more aware of what mediation offers. And in fact, if you look at it, there are a number of boxes which are important for people in business. There is time, there is cost, there is having control of the process, there is not being subject to risk, and there is respect for relationships. Every one of these boxes, when they look at litigation, it is an adverse tick. Every one of these boxes, when you look at mediation, it is a positive tick. And this is something business needs to realize. And also to realize that you lose nothing by trying a mediation, because if it's not going to work, you will know in 2 sessions. And if it works, it may well, finish it off for you in 4 or 5 sessions. So there is no loss in trying it. There is an extra tick, I think, when it comes to business India, and that is because in family business matters, mediation brings a sensitivity which is much needed. A sensitivity to the people at the table, a sensitivity to the fact that you're probably dealing with a multi-generational conflict, and a sensitivity to be able to conduct the mediation in such a way that you involve people who are not just named in the list of parties in the court case. Another big area is government disputes, disputes where government is a party. And government is a party in close to 50% of disputes in India. I had an interesting meeting with Mr. Gadkari some time back. I found him extremely sharp, man. And we talked about mediation, and he said there is one problem. And I said, I know what your problem is. Your problem is that your officers cannot take decisions because they are then scared of being hauled up by the CVC or the CBI or the Red Sea. He said, yes. Can we do something about it? So we in fact came out with an idea by which government could create a high-level committee, headed perhaps by a Supreme Court judge, staffed by former CBI, CVC, whoever they wanted, ex-finance, etc., whoever. But that officers would be free to enter into negotiations for settlement, whether it's bank cases or cases, shipping, highways, ports, etc., whatever. But they would take the settlement draft to this committee. Now, this committee would either say, yes, we approve, or would say, no, we don't approve, or would say, go back and renegotiate on these terms. But once the committee gave its approval, then by law, the officer should have immunity. By law. And I told Mr. Gadkari, I said, if you can do this, you will resolve any number of cases. He was very attracted to the idea. I don't know, perhaps we will see something like that. But the seeds of this have now been sown in sections 48 and 49 of the Mediation Act. At least an enabling for government to set up systems to handle these cases where government is a party. I just want to focus a minute on an interesting thing India has done, which is to use mediation for the larger public disputes. Disputes involving communities, involving states, involving religious communities. And the court playing a proactive role in that. The court itself suggesting the mediation, the court appointing the mediators, the court monitoring the mediation, sometimes aiding it along in small ways to see that it progresses. And ultimately, if something works out in the court, giving effect to it in its orders. I've been fortunate to be in at least three of the big ones. A border, 500 square kilometer border dispute between Assam and Nagaland in 2011, where, while we couldn't redraw the border, we brought in a system of border peace committees comprised of both Assamese and Nagas, apart from other initiatives, which has worked very well. So we have not had significant instances of violence, whereas earlier hundreds of lives used to be lost. A dispute between the Parsi community on whether certain priests could be allowed to pray in the Dungarwadi, conduct services in the Dungarwadi in Bombay. And although that seemed a highly unlikely matter for mediation, when it first came, I said, how would I mediate? This is a religious dispute. But sometimes persistence plays off. Over 2 years, they came to an agreement on that, the traditionalists and the reformists. So that's one lesson. You never know. You never know what can happen in mediation. And the third, of course, is the Janambhoomi Babri Masjid dispute in Ayodhya. There is a lot to tell about that. There is a lot also which I cannot speak at a public forum because there is a binding of confidentiality arising out of that. But this much I think I can say. I can say that during the proceedings, there were so many groups involved, both Muslim and Hindu, Buddhist also. And there was a certain broad consensus of view. I can't say it's shared by everybody, but a broad consensus of view that yes, this particular land will have to go this way, will have to go to this group, but that all other places of worship should be protected. And that's a broad consensus of view which many significant parties actually endorsed in writing and gave to the court. And I think when the court did finally formulate what it did, this I think was there, very much there in its mind. I must tell you one other thing. It's deeply personal. I started that mediation in 2019, 8th of March. And it finally ended end of November 2019. And I think for almost every day during that period, I bore this burden of feeling that if anything went wrong, if there was communal violence or a carnage, if anything went wrong, whether it was because of me or not, I would take the brunt of it on my shoulders. I knew that. And I worked under that, with that for 9 months. I think it's only some readings from Savitri and Ramana Maharshi which kept me going. And the judgment was posted on a particular date, middle of November. And the country was placed on full alert. Alert higher than foreign invasion, higher than internal emergency and higher than foreign invasion. And everybody was, of course, waiting with bated breath, me probably the most. But it went off without not only a single loss of life, it went off without incident. And for that, I think mediation and mediation efforts can claim a little bit of the credit.
You have been listening to BIC Talks by Bangalore International Centre. If you like what you heard, do follow us on social media. Keep up with our programming by signing up for our mailer on the website or leave us a review or rating on Apple Podcasts or iTunes. The crew that makes these podcasts possible is Gaurav Krishna and Ishan Gupta on sound supervision and production, with support from S. Sarunaraj and Raghu Tenkaila. Artwork is designed by Chandni Venkataraman of Crisscross Design Studio. Don't forget to subscribe to our channel on your favorite podcast platform. It can also be accessed on our website, bangaloreinternationalcentre.org. This is Lekha Naidu signing off on behalf of everyone at BIC.